good morning, good afternoon, or good evening, depending on wherever you are. It is my utmost pleasure and privilege to invite you to this session. Before I formally begin, let me thank Professor Michael Waibel for his time, for kindly agreeing to speak at our event this evening. Before I talk anything on his today's topic, let me say a few words about Professor Waibel. Professor Michael Waibel is a professor of international law at the University of Vienna. His teaching and writing focus on international law, international economic law, sovereign debt, and international dispute settlement. He has received several prizes for his writings. He is co-general editor of the Isds reports and co-editor-in-chief of the Journal of International Economic Law. Before joining University of Vienna, he worked at the Lauterbach Center for International Law and as the director of studies at Jesus College. Now, if I may talk a few things about this evening's topic, it's a very stimulating and I would say a very debated topic. Various corners have various observations regarding this investor-state dispute settlement mechanism, what we call as ISDS mechanism. There are those who say that ISDS is necessary for protection of foreign investors in an overseas territory. There are many who say that this ISDS mechanism is often too rigid. The jurisprudence that thousands of treaty-based ad hoc mechanisms produce, they are often incoherent, maybe at certain points on certain matters, maybe even inconsistent. There are many who say that the arbitrators, who are often working as ad hoc arbitrators, they have some perverse incentives to act in certain ways which may protect the interest of those who are appointing them. There are some scholars who feel that the interest of some developing countries have not been sufficiently protected in the ISDS mechanism. There are Latin American countries who even have taken the dramatic step of withdrawing from the Isds mechanism. Now, if those are some of the criticisms, those are some of the concerns about the ISDS regime, what about the reform? As far as I am concerned, I think while some of the critics may have some valid points, when it comes to what the regime should do, many of the recommendations have not been that strong or have not been that solid. So I eagerly await to see what Professor Waibel's take is on the issue of reform and what he covers with regard to the issues that he feels are pressing in the contemporary ISDS regime. With that note, I once again thank Professor Waibel, and I thank you, dear audience, for your time this evening. I look forward to your questions. Thank you. Professor Waibel, the floor is yours.
Thank you so much for this very kind introduction and the invitation. Delighted to virtually visit North-South University, my first virtual visit to Bangladesh. And thank you all for joining late on a Friday evening. So my topic today, the backlash and reform of investor-state arbitration, is a topic on which I have been working for some time together with three colleagues. I co-edited a book entitled The Backlash Against Investor-State Arbitration. This was published in 2010 and was based on a conference that was held in 2008. And at the time, there were already some serious misgivings about how the investment treaty regime, and especially how investor-state arbitration operates and the effects that it has. And I think it's fair to say that these concerns have only grown in the last decade. The rise of investor-state arbitration has given rise to many concerns. And if we look at this from today's perspective, there is really an unprecedented degree of concern in both developed and developing countries. And the concern has been gathering force, especially in developed countries over the last decade. And I want to discuss with you tonight some of these concerns and then bridging to what might be possible reforms. There is an ongoing reform process at Arbitral, which focuses on the procedural dimension of investor-state arbitration. And it remains yet to be seen how that reform process will unfold. But what we already know is that there are reforms that are undertaken by individual states. Consider, for example, that the role of investor-state dispute settlement has been scaled back in a major way in the US MCA. The NAFTA 2.0 concluded by the United States and Canada of years ago. Under that major trilateral agreement, there is no more general recourse to investor-state arbitration between the United States and Canada, with some exceptions for legacy claims, for legacy investments and pending claims. And insofar as Mexico and the United States are concerned, there is only a more limited version of investor-state arbitration. For example, it is now, as a rule, required that investors exhaust local remedies, something that is not the rule in investor-state arbitration more general. And it has also been ruled out that arbitrators could ever review a decision by a host state under that agreement to block a new foreign investment. And that is in keeping with growing concern in many countries about inward foreign investment for national security and other reasons, and a growing number of procedures and a higher degree of intrusiveness with which these investments are reviewed. Some go so far as to say the backlash has gathered such force that some go so far as to say that there is now a fundamental lack of trust by the public in investor-state arbitration. Those are the words of Cecilia Malmström, the then EU Commissioner in charge of trade. And she has said at the time, a couple of years ago, that regaining this trust of the public, and she has in mind the trust of the European public, requires a more inclusive, a more transparent, and a more legitimate process of investor-state arbitration. And it's against that background that the European Union has advanced a proposal for a permanent court, a permanent mechanism to replace ad hoc investor-state arbitration. But there are various concerns, and some of them are very significant concerns by other states about this proposal. Now, here is what I'd like to briefly discuss with you this evening. I first would like to say a few words about the functions of investment arbitration, or investor-state arbitration, and then look at some of the main criticisms of how the investment regime, investment treaties, and especially investor-state arbitration currently operates. I have listed 5 specific points there, and then in a third part, discuss avenues for reform and invite any questions that you have, I think especially perhaps on the reform side, what kinds of reforms might be desirable in view of the shortcomings that some have diagnosed. So let me come to the functions then of investment arbitration. As you can see on this slide, I have here contrasted two opposing views of investor-state arbitration. One paradigm, the traditional paradigm, is based very much on a traditional understanding of arbitration. It's rooted in international commercial arbitration, in interstate arbitration. That what arbitration is all about is to resolve a particular dispute between two or more disputing parties. And there are really two functions that the tribunal carries out. It is there to find facts, to state with authority what the facts are, and to settle the dispute between the parties to that dispute. Now, an alternative view that departs to a significant degree from that traditional paradigm is that investor-state arbitral tribunals, in contrast to some other types of arbitral tribunals, are engaged in additional functions. They not only settle disputes and find facts, no, they also develop the law, particularly because we have a number of very open-ended treatment standards in investment treaties. Think about fair and equitable treatment. So it's really in investor-state arbitral tribunals that have developed that standard into what it is today, and they also engaged in governance. In what is meant by that, what I mean by that is that investor-state arbitral tribunals develop their own conception of what is the appropriate exercise of public power vis-a-vis foreign investors. And this is governance because it is not limited to the specific dispute at hand, but it has repercussions. It has spillovers far beyond the individual dispute at hand. And whether one adopts the traditional paradigm or the alternative paradigm has significant implications for how one might view a number of aspects of investor-state arbitration that I'm now going to take a look at, such as the question of transparency or coherence. And that leads directly to the second part of my talk, major points of criticism about the investor-state arbitral process and investment treaties more generally. So I've already mentioned, this is just by a way of background, that there is this ongoing legitimacy crisis, and one that has been gathering force, especially in developed countries. And this is something relatively recent. Until 2000, there was virtually no concern whatsoever in developed countries about investor-state arbitration. And a cynic might say this is because developed countries as a group never faced the threat of investor-state arbitrations. This was just something that happened elsewhere, largely in developing countries. It was developing countries that felt the sharp end of the stick of investment treaties in the form of investor-state arbitration. And as a result of that, there had been some backlash. But of course, developing countries as a group aren't as politically influential as developed countries as a group. So there wasn't the same level of concern. There wasn't the same momentum for reform at the time. And a lot of this criticism is specifically or also about the mechanism of investor-state arbitration. So let me come to a first criticism. And that first criticism is that there is a fundamental incompatibility between investment treaties backed, underpinned by investor-state arbitration, and sovereignty generally, and a variant of that concern democracy in particular. So how might we think about this concern? So with respect to sovereignty, first of all, investment treaties are long-term international agreements. And one of their functions is to tie the hands of governments. Governments come and go, and it may be in the interest of one government to tie the hands of future governments, to ensure that there is a relatively stable framework for foreign investment. And one way of doing this, certainly in recent decades, has been to conclude investment treaties. Other avenues have been more prominent before, such as stabilization clauses included in contracts between host states and foreign investors. But in the last several decades, investment treaties really came to the fore. So it's because of these far-reaching consequences that at the very general level that these investment treaties have for what conduct a state can undertake without becoming liable to foreign investors, that some see a fundamental tension between investment treaties underpinned by investor-state arbitration and sovereignty. Now, of course, the traditional response of the international lawyer to this is treaties. Any treaty, be it an investment treaty, a human rights treaty, an extradition treaty, or any other kind of treaty, is an expression of state sovereignty. This was already stated by the Permanent Court of International Justice in the Wimbledon case in the interwar period. So rather than being in tension, in conflict with sovereignty, investment treaties, just like all other treaties, are a way for a state to exercise its sovereignty. There is no conflict at bottom. But one might say that there is something peculiar about investment treaties, particularly due to investor-state arbitration. These treaties can have very significant bite far into the future, and they can, certainly as a factual matter, curtail policy space for a state for decades into the future. So in that sense, there is arguably a qualitative difference between investment treaties on the one hand that have these far-reaching effects and other types of treaties, such as extradition or human rights treaties, which aren't underpinned by the same type of enforcement mechanism and thus have far fewer teeth. They leave governments in practice much more room for maneuver. Now, a specific variant and democracy. This, of course, only applies to a subset of states that are democracies, though, of course, democracy is a sliding scale. No state is a perfect democracy, and we have states where we have very limited democracy to states where we have quite a lot of it. So there are lots of shades of gray. But the general concern here is the following, that there should be leeway for a democratic polity to change its mind. It may be that the policy preferences change over time. We may have a major disaster with a nuclear power plant, as in Fukushima. And as a result, a country may decide that going forward, it doesn't wish to have any nuclear power plants on its territory. The risks it may consider in light of that disaster are simply too great. So the question is it appropriate then for investment treaties in such and other circumstances to constrain the choices in effect of the majority of a state that is a democracy? Now, there are a number of counter arguments to them, and they resemble some of the counter arguments I have mentioned when it comes to sovereignty, the more general concern, and investment treaties. That is, we can say the same thing of human rights treaties, for example. They also constrain. That's the very point of many international agreements. Another counter argument has to do with the nature of the remedy. The dominant remedy, and really in practice the only remedy in investor-state arbitration, is compensation. And that also means that host states retain freedom for maneuver. They can go ahead with implementing their the policy preference that have been expressed in a democratic vote. It's just that if, for example, a host state decides to engage in major land reform because inequality has become a major concern, for instance, that the host state becomes liable to pay compensation. So it can, at least in theory, carry out the reform that is desired by the majority of the people. However, that, of course, may in practice not be so different from being prohibited from engaging in the reform in the first place, because it simply may become too expensive for the government concerned. Now, this concern is arguably also more prominent when it comes to measures that are of a general legislative nature. So if we have a general law that applies to many actors, and this type of and this measure is indirectly challenged in investor-state arbitration by investors, perhaps multiple investors, as we've seen, for example, in claims by investors brought against rolling back subsidies for renewable energy in a number of countries. But many measures that investors challenge in practice aren't of that general legislative nature. They are rather more targeted measures that apply to one or several investors. They're adopted by administrative agencies and the like. And for them, this is arguably not such a big concern. And then, of course, investment treaties have been adopted to the extent that they are in force according to whatever the applicable domestic requirements for expressing consent are. This applies to both democracies and non-democracies. So there is something to this concern, but ultimately it is probably not entirely convincing. So let me come to another concern, namely the concern about regulatory chill. And this is one level down from the concern about sovereignty and democracy. And here, the concern is really that the host state is not capable of protecting, of implementing certain policies that are important, serve an important public interest, because it is chilled by investment treaties in combination with investor-state arbitration. How so? The idea is that the threat of investor-state arbitration makes a government reconsider its preferred course of action. So a state may, for example, think that it's desirable to adopt measures to combat large-scale smoking and adopt plain packaging legislation, as Australia and Uruguay have done about a decade ago. And then there were other states, such as New Zealand, they were closely studying this experience and took active steps to implement a similar measure. However, New Zealand was concerned, and this is a specific example of regulatory chill, that it would also face investor-state arbitrations, just like Australia and Uruguay. So it preferred to delay the introduction of this measure pending the outcome of these arbitrations against the two other states. So this is a concrete example of where regulatory chill has been realized. However, more generally, we don't really have a very good sense of how widespread this phenomenon of regulatory chill is. It is difficult in practice to isolate whether it is truly the investment treaty with investor-state arbitration that chills governmental conduct, that leads a government to refrain from a course of action that it would otherwise pursue. That may be because there are other factors that are in play. There may be domestic interest groups that put pressure on a government. There may be domestic law, including domestic constitutional law, that lead the government to not adopt a measure that it considers to be desirable. So against that background, it is difficult to say with certainty to what extent a regulatory chill is really a major concern in the investment regime. It's very hard to measure, and it also ultimately requires us to have a concept of what governmental interferences with investor rights are legitimate and which are not. If we don't have such an overarching concept, then we can't develop a measure of a regulatory chill. Now let me come to a third concern, and that concern is really about the lack of transparency and is tied closely to the traditional paradigm of arbitration. That is, it is about solving a particular dispute between two or more disputing parties. There are no spillovers. And so what goes on inside the arbitration, what the arbitral tribunal does, is only of concern to the disputing parties. Hence, there is no need for transparency, because it is simply of no interest to others what goes on inside the arbitral process. And in fact, it may be that for some states or many states and many investors, this confidentiality of the arbitral process is a key benefit of this form of dispute resolution. Perhaps it's the only benefit that is left, given that arbitrations in the recent investor-state arbitrations in the last 2 decades take a long time, years on average, and have also become very, very expensive. So keeping perhaps certain uncomfortable features of a relationship out of the public domain may be very attractive to both host states, their governments, and to investors. Now, there have been some limited attempts to introduce more transparency, but like other reforms that have been undertaken, this is a slow process. Most prominently, we have the Mauritius Convention on Transparency, but few states have ratified that convention. So we have at best a piecemeal incremental reform in that area. And there is also common, and this is perhaps an intermediate form of achieving a somewhat higher degree of transparency for parts of awards and transcripts, as you can see in these examples from Gabriel Resources in Romania, and Philip Morris in Australia to be simply redacted. So if we have these types of documents in the public domain, we at least have a pretty good sense of what is going on as researchers, as others interested in investor-state arbitration, but key bits and pieces may not be in the public domain. Then we have consistency. Investor-state arbitration is a very decentralized, fragmented process, and there isn't any overall coordination, apart from the very limited coordination that is performed by the secretariats of the major arbitral institutions, ICSID and the Permanent Court of Arbitration. And what this decentralized character implies is that we have a real risk of inconsistent decisions, and there are several well-known examples. And this inconsistency can arise with respect to different dimensions. It can arise with respect to how certain treaty standards are interpreted by two or more tribunals, and how the facts are considered by two or more tribunals, or the outcome of an investor-state arbitration. A famous example, for instance, two cases brought against Argentina, CMS and LG&E, where against the background of very similar facts, one tribunal, the CMS tribunal, found that the requirements for the state of necessity were met, whereas the LG&E tribunal found exactly the opposite. Now, it may be that some of this inconsistency can be traced back to variations in the underlying applicable treaty. That wasn't a potential explanation in the specific conflict that I just mentioned concerning two cases against Argentina, but in some cases, it can be an explanation. But we are likely to see a certain level of inconsistency in such a highly fragmented regime, where arbitrators are only appointed for particular disputes, and where it matters to a considerable extent who these arbitrators are. And that is because not necessarily all the actors, and I'm thinking here especially of host states, have a shared interest in consistency. So think about a state that is facing dozens of investor-state arbitrations. The first best outcome for the state is that it consistently wins every single of these arbitrations. But the second best outcome isn't that the state consistently loses all these arbitrations. The second best outcome from the perspective of the host state is that it wins a large percentage of these cases and loses a small percentage of these cases. So inconsistency from the perspective of the host state is better than consistency. Why? Well, this inconsistency can be helpful. It can be helpful because it can cast doubt on the majority of cases that the host state has won, can cast doubt on the arbitrations that the host state has lost, and it might help with annulment proceedings, with set-aside proceedings, if we're looking at non-ICSID arbitrations. So a host state that is facing multiple arbitrations might really like a certain degree of inconsistency. It in effect allows the possibility of a horizontal appeal. In every new case, you can relitigate the dispute, even if these disputes are very similar on their facts. And again, this goes back to whether this is just about resolving particular disputes, in which case if we are adopting this traditional paradigm, it really doesn't matter if we have inconsistency, because we just look at one dispute at a time. Or are there significant spillovers from one arbitration to another? Should we really look at this with our systemic glasses on, in which case incoherence may be a serious concern. And then one might have to think about ways in which the degree of inconsistency in the investment treaty regime could be lessened. So these are 5 examples of major concerns that have been discussed at length in the literature about how investment treaties and investor-state arbitration operates. And in terms of reforms, there is currently a reform process ongoing at Arbitral. That reform process, it's fair to say, has been slow moving. Not much progress has been achieved. There aren't any concrete final proposals expected until 2025. And partly as a result of that, some states have taken matters into their own hands. They have terminated or renegotiated investment treaties. And also knowing that the Arbitral reform process is limited to procedural aspects of investor-state arbitration. So it doesn't touch on a major feature of the contemporary investment regime, the breadth of the substantive standards of treatment that we find in many existing investment treaties. And there is very much an ongoing debate about whether incremental reform, sort of tweaking on the margins, is enough. So retaining investor-state arbitration, but making sure that certain major concerns are addressed, such as arbitrators, counsel, and experts wearing multiple hats simultaneously. So one and the same person acting in 2 or more of these capacities. But others consider that we really need more wide-ranging reform, perhaps such as the European Union, that we need to move away from this fragmented ad hoc way of settling disputes, because a major concern is inconsistency and the lack of predictability. If you believe that, as the European Union seemingly does, then something modeled along the lines of the WTO's dispute settlement body is perhaps the way to go. And still others consider that really investor-state arbitration is beyond saving, that we need radical reform, that the only way to save investment protection internationally is to get rid, or largely get rid, of investor-state arbitration and replace it with something else. Though then, of course, the big question is, what is the real alternative? Is it non-binding mediation? Is that really the way forward, as Brazil has been championing in some of its recent investment treaties? Should some of these or all of these investment disputes really be decided by national courts in the host country? Why insist on an international forum when domestic courts are just as capable and are not necessarily slower or more expensive than international arbitration? So this, by way of a survey of what some of the key concerns and possible reforms are of the investment treaty regime, with a focus on investor-state arbitration. So thank you very much for your attention, and I very much look forward to your questions and comments.
Thank you, Professor Waibel, for your presentation. Let me ask the questions that we have received from the attendees. The first question that I would like to ask is, if there are too many standardized rules on arbitrator selection, would it in some way threaten the party autonomy, which is perhaps the thrust of the Isds regime?
Well, I think it does mean a reduction in party autonomy if you have a significant expansion of rules that govern the selection of arbitrators. But I think at the same time, I mean, party autonomy, I would consider that to be an important value in the context of investor-state arbitration and in arbitration more generally. But it's of course not the only consideration. So it's not an absolute value. It's not something that cannot be curtailed. So I don't think ultimately party autonomy or the principle of equality of arms between the parties stands in the way of reforms that are otherwise desirable to be implemented.
Thank you. The next question that we have is, would a permanent foreign investment court address some of the concern that critics have about the current state of things in the ISDS regime?
Yes, I think it would address some, but I think the key word is some of these concerns. So I think the concern it would almost certainly address, and perhaps the only concern it would squarely address is the concern about the lack of coherence. Now, of course, one cannot expect, if there is even such a thing as perfect coherence, even from a permanent court. There's always going to be room for argument that a permanent court isn't coherent, and we can observe that with national courts in a whole number of jurisdictions, such as the US Supreme Court and so on. But I think it is a likely outcome if we were to move towards a permanent investment court that the level of incoherence would be reduced. But as I've said in my talk, this is not necessarily what best serves the interests of all the actors in the investment regime, and in particular of host states. And when it comes to some of the other criticisms, I am doubtful whether a permanent investment court really addresses these concerns. Of course, a lot will depend on how such a permanent court does in fact operate, and perhaps also who sits on such a permanent court. But I think that the sovereignty and democracy concerns, they're still going to be there. In fact, that's probably one of the reasons why several important stakeholders, several important states aren't very keen on a permanent court. To put it diplomatically, the United States being a very good example. So it has long taken the view, not just in this area, area, but in others as well, that the sovereignty costs of permanent international courts are too high. We have seen that play out in the WTO. So I think when it comes to the sovereignty and democracy concern, the permanent court probably does very little. Same applies to regulatory chill. Transparency, yes, we might expect that there to be an improvement, but again, it all depends on the precise parameters under which this permanent court operates. There are certainly examples of courts that are very intransparent. A good example is the Court of Justice of the European Union. You can't observe what is going on apart from seeing the judgment, but the proceedings aren't open. So there too, we have significant variation if we look at national courts.
Thank you. The next question that we have received is, why are there so few arbitrators from Asia, Africa, and why are there so few female in the ISDS regime?
Yeah, so I think, that the answer probably has multiple dimensions, but let me perhaps tell you what I think is the most significant factor. So I think there is substantial path dependence in arbitrator selection in the following way. This isn't inherently discriminatory vis-a-vis women or vis-a-vis arbitrators from particular regions of the world. But because we started out, for whatever reason, with mostly arbitrators who were men in the 1980s and the 1990s, and mostly arbitrators with the nationality of OECD countries, and because the disputing parties have, under the current system, a huge degree of autonomy on who to nominate as the party-appointed arbitrators, we have ended up with these people who were appointed in the 1990s and thereafter, to the extent that they're still active, being appointed again and again. Why? Because there is a belief among disputing parties that it is valuable, it serves their own cause if an arbitrator has a lot of experience, has prior appointments, that it makes that arbitrator carry more weight on the tribunal, that arbitrator may be able to sway the tribunal's decision in its favor. So from that perspective, appointing someone new to an arbitral tribunal is a riskier strategy, and that's something that many disputing parties are not prepared. That risk is something that they rather avoid if they can. And I think that's also the major reason why initiatives, both private and of arbitral institutions, to increase diversity when it comes to gender, geographic spread, have only made limited progress thus far. That there is this deeply ingrained bias towards arbitrators who have a lot of experience.
Thank you. The next question is also about the selection of arbitrators, or I should rather say the performance of arbitrators. The question is, do you see any obvious pattern in terms of the arbitration by star arbitrators vis-a-vis those who are like novice or who are only appearing in one or two arbitrations?
So the question was whether I see any obvious bias.
No, any obvious pattern in terms of the approach that the star arbitrators take vis-a-vis those who are not so frequently appearing in the arbitral tribunals.
So I think it's a really interesting question. It's not something that I have studied systematically, empirically. So this is more of an educated guess, or perhaps an answer that is based more on theoretical considerations than backed up by empirical findings. I think if you are a novice arbitrator, there are going to be incentives for you to not to be relatively restrained. I think there's probably quite a lot that you still need to learn about the process. So I think just like in other contexts, if one hasn't been doing something for some time and is new, the best approach, insofar as the individual is concerned, is to listen a lot, and rather than sort of going in and pretending as if one knew all the answers. So I would expect novice arbitrators to be less assertive than very experienced arbitrators, and that's perhaps one part of the reason why experienced arbitrators are in general preferred by the disputing parties. I think it might also create incentives for novice arbitrators. The incentives might be stronger to side with their appointing party. because if you think about the career incentives of novice arbitrators, one sees in the data that the majority of arbitrators never get past their first appointment. So if you are, if you agree to an arbitral award that goes against the party that appointed you, that might well mean that it's going to be a greater struggle to get your next appointment. So I think there are theoretical reasons to believe that experienced arbitrators may in fact become a bit more independent from their appointing parties compared to novice arbitrators. But I would also expect, maybe just one final thought, I would also expect that experienced arbitrators might be thinking about a particular arbitral decision much more in a dynamic context and thinking about all their other cases where they have already set and where they might sit concurrently and where they might sit in the future. So I think these strategic considerations are likely to be much more important for repeated arbitrators than for one-time or novice arbitrators.
Thank you for that answer. The next question that we have is, would it be a fair criticism that often arbitral tribunals have not paid enough attention to the necessity of the host states?
To the necessity of to the needs of the host state?
Yeah, that's the question. Thank you.
I think one can certainly give some examples where it seems as if the arbitral tribunal lacks an appreciation of the circumstances on the ground. And of course, that is a general criticism that has been made of investor-state arbitration, that we have these elite professionals, these arbitrators. They, in the pre-pandemic times, convened in one of the world's great cities, usually without necessarily having any local knowledge or understanding. They usually come from very homogeneous backgrounds, largely OECD nationals, and so on. And that they may view the particular dispute very much through the prism of their own professional and personal experience and trajectory, and not be sufficiently sympathetic to the particular needs and difficulties that a government may be facing. They may be too demanding in terms of what governments can realistically do, even governments with considerable capacity. So I think there are some examples of that that can be given. Whether that can be said of all arbitrations, I'm not so sure, but I'm thinking in particular about financial crisis cases where I think there has been a tendency to not grant much, if any, deference to host governments when it comes to the crisis response, which I personally think is a problematic feature of some of these cases.
Thank you, Michael. The last question, we are almost out of time, so this would be our last question. That by allowing amicus curiae briefs, would there be a risk of making the ISDS regime needlessly cumbersome?
I think there's a risk that amicus curiae participation increases the cost marginally of investor-state arbitrations, but I think investor-state arbitrations are already pretty cumbersome. They take a long time, almost 5 years on average. They cost nearly $10 million on average. So I think the effect of amicus curiae participation, at least if it is not, if we don't have a large number of amicus curiae in a particular dispute, is likely going to be pretty minor. So in the big scheme of things, it's unlikely that it will have a major impact.
Thank you for that answer, and thank you for the excellent presentation. I'm sure this would give rise to some new questions to the mind of our participants, and I'm sure some of them would be more inclined to study some of these questions, maybe more in greater detail. Thank you very much for your time once again, Professor Waibel. Thank you, attendees. It has been a pleasure to host Professor Waibel this evening.
Well, thank you very much all
Goodbye.
for joining, especially at 9 p.m., 9 to 10 p.m. on a Friday night. I don't think I've ever given a talk attended by 100 people or so on so late on a Friday evening. So thank you very much for giving up your time and your questions.
Thank you once again.